Recognize the ranking member of the Judiciary Committee, the gentleman from Ohio, Mr. Jordan, for his opening statement.
Excuse me. Thank you, Mr. Chairman, for convening today's hearing. First, I just want to thank our witnesses for courageously agreeing to be here today. The Judiciary Committee is charged with safeguarding America's most fundamental rights, and we all know that a right without a remedy is no right at all. We must make sure that the pathways that Americans have to resolve their disputes function properly and are fair to everyone. That is true for our court system and for other dispute resolution mechanisms like arbitration. In fact, Congress enacted the Federal Arbitration Act nearly a century ago, and today arbitration provides an alternative to the cumbersome and expensive process of a civil lawsuit. Arbitration is a process that should be as fair as court, but also easier, more affordable, and much faster. Going to court can be extremely expensive if you are an average citizen bringing suit against a major business entity who has an army of attorneys. As we examine the benefits of arbitration and the areas for reform, we should be careful not to frame the question as one of arbitration versus jury trial in a court. Over the last 90 years, the number of civil cases that reach conclusion through trial has declined substantially. In other words, if you're not in arbitration, it is highly likely your alternative to resolve your dispute is a protracted settlement negotiation involving major attorney fees. We all understand the benefits that arbitration provides. However, if the arbitration system is not functioning properly and is being used to stifle individual rights, we have an obligation to fix it. But any reforms must be done in a way that benefit the parties to the suit and advances the interest of fairness and justice. It would be wrong for us to to make reforms that do not benefit the parties to the dispute, but rather enrich the lawyers who seek to exploit suffering and hardship by taking a major cut of any damages that are awarded. Finally, I would like to thank again all of our witnesses for their testimony, particularly the witnesses who have shared their personal stories. Thank you all for taking the time to be here today to help us better understand how our arbitration system needs to work. Thank you, Mr. Chairman, and I yield back.
Without objection, all other opening statements will be included in the record. I will now introduce today's witnesses.